So I'm kind of falling down on my job. I'm supposed to be introducing people. So, this is Sharon and Lindsay from the North Carolina Innocence Inquiry Commission.
Thank you. As she said, I'm Sharon. I'm the Associate Director of the Commission, and this is Lindsay. She's our Associate Counsel. And we're going to try to give you guys a brief overview of what the Commission is and then how we interact with law enforcement agencies.
Before Sharon starts, we're also the Commission's evidence custodians, which is the main reason that we attend these things, because we do take evidence into our custody at our agency, and we're responsible for it.
So, what is the Commission? We're a state agency charged with investigating and evaluating post-conviction claims of innocence. So that means we don't take anything pre-trial, while it's in trial, while it's in the appeal process, or all the way at the back end. We were created in 2007, and the reason we were created is to have a body that can hear innocence claims outside of the court system, the traditional appeals process, or MAR. And we also we were granted with authority to use criminal and civil procedures. So sometimes, if you've had interaction with us before, you know that we will quote a statute to you and come in and do a search or look for evidence, and that's where that comes from. A lot of times, the easiest way to kind of tell what the Commission is to start by telling you what we're not. We don't represent claimants, not ever. So there is a process where the inmate who is claiming innocence will have counsel. It's never associated with our office. Also, when a claimant is applied to the Commission, they waive all of their constitutional protections. So they waive their Fifth Amendment rights. A lot of people ask us, when you interview inmates, can they refuse to tell you something? And they can, but then we can close their claim. Inculpatory evidence is not protected. And what that means, a lot of times on our questionnaire forms, when people apply to us, they're applying, say, for a rape, and they're saying they didn't do it. And there's a question on there that says, can we run your DNA through the data bank? And they will say no. And the reason they'll say no sometimes, well, there's two reasons. One, they don't trust anyone. And two, it's going to hit in CODIS to something else and they know it. So we would, if you said no, if a claimant said no, we would automatically close their claim. So we turn over evidence of all wrongdoing. So whether that's a DA's office or an inmate, if we find evidence that you've committed another crime, that you did additional crimes, it'll always be turned over to the DA's office or the law enforcement. The other thing that people don't know about us is we're not political or policy driven at all. You'll hear us say constantly that we're a neutral fact-finding agency, and that is because we are, and we don't take a side. We're not out there trying to convince you that there's innocent people in prison or that there's guilty people in prison. We're just out there trying to find the truth. We don't make our case lists public, so people don't know when we have the claims. The exception to that is when a case goes to hearing or when we're really involved in a case, sometimes a defense attorney or a district attorney will talk to the media, and they'll tell the media that we have the case. So, I mean, it does get out, it happens, but it doesn't come from us. And we also don't take position on any policy that's not related to the Commission. The only time you'll see us in the legislation is when we're trying to get something related to us. So the cases that we take, you have to be convicted of a state crime, so we don't take any federal cases, and it has to be in North Carolina. It has to be a felony, and you must be living. We've actually had a claimant a while ago that died while his case was under review, and we had to close the claim. You must be claiming complete factual innocence. So that means you can't be an accessory, you can't be an accomplice. No self-defense, you don't do any claims like that. Diminished capacity, a lot of times drunk drivers, things like that, we don't take anything like that. So, claiming lesser.
No lesser included conspiracy, accessory, before or after.
And so our job is to look for the new evidence of innocence. What we don't do is retry a case. If you were convicted at a jury trial and there's no new evidence, even if there was great evidence of you being innocent, we don't look at it again. What we're looking for is something new. Most people know that something new is DNA testing, but it can also be a recantation or an alibi, something that wasn't presented, and it must be credible and verifiable. The way that we get our claims, inmates either directly apply or they can be referred to us by an attorney or another agency. When the commission was first created, we got a lot of claims from the governor's office, just inmates who were writing state agencies to get help. That's kind of slowed down a little bit over time, but we still get a lot of attorneys referring cases. So we do all the screening and we do all the investigation in-house. We don't use any other agencies to help. We do look at all the files from the other agencies, but we don't involve them in our actual investigation. Formal inquiry. So when a case goes to formal inquiry, those are the cases that most people hear about, the ones that get in the media, the ones that you'll hear are having a hearing, and that's only about 2% of our claims. We'll go over the stats with you in a minute, but it's a very small number of cases that ever get that far. 98% of the claims get rejected right off. Talk about their protections.
Sure. During that formal inquiry process, that's when the claimants will waive those procedural safeguards that we've talked about. Some of the ones that you all will think of are like attorney-client privilege. I know law enforcement often thinks how great it would be to be able to kind of break that privilege and talk and find out what a defendant has said to their attorney. Well, we actually have that opportunity. They're required, once the case is in formal inquiry, to turn over all of their attorney files. We'll often interview their attorneys and we'll get affidavits from them so that we know if they ever told their attorney, I did it. And that would, of course, close the case. Some of the lesser known ones that they no longer have is their spousal privilege, privilege they have with their clergy, the doctor-patient privilege, and then, as Sharon mentioned before, their right to plead the fifth. They can't do that as well. Also, under formal inquiry, they do have a right to counsel that's triggered, so they would be assigned counsel if they were indigent and did not choose to waive that, or they could hire their own attorney if they were able to do that. And the purpose of that is for that attorney to help them understand what they are giving up. That doesn't mean the attorney can then advise them not to talk to us unless they are advising them that they should, have us close their case. And this is also the time at which we are required by statute to give notice to the victim of the crime. As Sharon mentioned, 98% of our cases don't make it to this process, and so we try to avoid putting the victims through anything more than they have to be put through. However, when we hit formal inquiry, we're required by statute to reach out to the victims, and at that point, we typically ask the victims to provide someone in that family, either themselves or if it was a murder, like someone in the family, to be our communication, the person we communicate with, and so we keep them abreast of our investigation to the extent that they want to be made aware of what's going on.
So again, the 2%, if they make it that far, the next step, if we have verifiable, credible evidence, we're going to present it to our commission, and I'll go over who our commissioners are in a minute. And then a vote is taken by the commissioners to determine whether or not to send it forward to what's called a 3-judge panel. If it is a plea case, it must be 5 of 8. No. If it is a plea case, it must be 8 of 8, meaning all of them must decide unanimously to send the case forward. If it is a trial, it must be 5 of 8. So the commissioners, there are 8 members. These are the people that we will present our work to, our investigation to, and they're appointed by the Chief Justice and the Chief Judge of the Appeals Court. Right now, we have a Superior Court judge, a district attorney, a defense attorney, a victim advocate, a sheriff, a public member, and 2 discretionary members. One of those members now is the chief of police. He actually rotates off soon. And the commissioners serve a 3-year term. The maximum is 2 terms. So we kind of look at having them for 6 years, just depending on their schedule, but that is all up to the Chief Justice and the Chief Judge who appoints them. These are our statistics. These are only updated as of April, so the claims received is not very current. The total number of claims we've had since we began operating in 2007, again, it's going to be a little bit higher than that, but it's 1,300. I get asked a lot from people who hear about the commission, well, doesn't everybody in prison say that they're innocent? Yeah, that's probably true, but there's 38,000 people incarcerated in North Carolina, and we definitely haven't heard from all of them. So you are looking at a very small number of cases. The ones that we've closed since we began operation is 1,100. I don't know what our claims received now. It's probably about 100. We have 8 cases in formal inquiry right now. I do know that. So when I talked to you about them going to hearing, 5 cases have gone to hearing, and there's been 4 exonerations. But 2 of them were co-defendants, so there's actually only been, so 2 of them did not make it all the way through. And what happened with that is 1 was rejected by the commission and closed, and then 1 was found that there was not sufficient evidence by 3 judges. So there's been a total of 4 exonerations. And these are our statistics. People ask, what are the most common offenses that people apply for? It's usually murder or the sex offense cases. We do separate child victims from adult victims just for reporting purposes. And then obviously a lot of these cross over. So you have a lot of ones that are a rape and a murder or a robbery and a property crime. You might want to get that. And then the next question we get is, what are they claiming? People aren't always claiming that no crime occurred. Sometimes they're saying it wasn't me, it's a bad ID, or they're saying that they're guilty of a lesser, which as I talked about, that would be something we reject. They claim self-defense. Again, that's something that we reject. Consent of a victim is not, 1, that should have been available at trial, and 2, we would have no reason to contact the victim. So that is normally a rejection, but not always. Conspiracy of others to frame and convict, that's one we get a lot, and that's one where the police, the judges, the inmate feels like everyone kind of set them up. And that's generally a rejection because there's not a whole lot of investigation to do with that. These are the reasons that we commonly reject them. No new evidence is actually the biggest reason, but not claiming complete factual innocence is pretty close.
So now we wanted to talk to you all a little bit about kind of what your role is as law enforcement if you ever hear from us. One of the main reasons that we initially will contact law enforcement is to obtain a copy of your file. We have the statutory authority to get a copy of that file, and so we're doing that. It's not just you that we're contacting, that we're also trying to get the district attorney's file, we're trying to get the defense attorney's file. What we really want is everything that's out there and available so that we can have a full picture of the case in order to evaluate it properly. We also may ask to speak with the lead detective from the time of the crime. A lot of our cases are older. So sometimes we're dealing with individuals who no longer work at the agency or may be deceased, but if they're available, they sometimes can be the greatest resource to us because they may remember how evidence was stored, how they might have kept it in their office or at their home or wherever back then, and they may have memories of the case that even a paper file can't do justice to. We may also call to ask about your policies and procedures. This happens a lot with evidence. How is evidence handled? Back in 1975, how was evidence handled? How is evidence handled now? And we may be asking for that. We may also be calling to request that you all provide us with an inventory of the evidence that you still have, or maybe search for evidence in a case where we either know it's missing, have heard it's missing, or maybe no one's ever asked for it before. So our goal there is to find out what is available, if you still have it, and if you don't have it, if you have proof of destruction, so that we can easily say, okay, we know that it's no longer there. We may also request to come in and assist you with the search. We've done several of those. As I said, Sharon and I are the evidence custodians. We've gone through Joe Latta's training with the International Association of Property and Evidence and are certified in that. So we will come in and assist with searches. We like to do that in conjunction with the agency because our goal is always to protect the integrity of your evidence. We in no way want to be in your evidence room alone, and we want to work with you collaboratively. We have devised quite a list of kind of procedures that we go through with each agency to ensure that. And then lastly, we may request additional analysis or testing. If we're able to locate evidence, we may ask that it be transferred to us to send off to a lab. As I mentioned earlier, we do have a evidence room at our agency. It's small. We try to keep as little evidence here as possible. It normally comes in. We send it off as quickly as we can. And when we get it back, as soon as we close the case, we want to try to get it back to you because it ultimately lives with you, not us. So what do you do when you get a request from the commission?
Has anybody gotten one in here before? Where are you from?
Okay. Wilmington, right? Rocky Mount, that's correct. Okay, so what do you do when you get one? Well, typically what you're going to get is a letter from us. The first letter that we're probably sending out to you is going to be a letter to preserve. Normally, when you get that letter, all we're asking you to do is just don't get rid of anything that you may have. The letter may request an inventory at that time. It may request files. But typically, you may just see a letter that says, don't do anything yet. We have, again, a statute that allows us to require or request that things be preserved. And at the end of our investigation, when we are said and done, we're going to send you a letter releasing you from that requirement under our statute. That does not mean that you're able to just get rid of it at that point. There will be other statutes that are in that apply that require you to keep it for longer, and that is up to you to figure out. When we're asking you to do a little more, when we're asking you to produce evidence, we might be asking you to search for it yourself, provide a list of the evidence that was located, provide the records of destruction if you're saying it's been destroyed. We want to see those records if they're available. If you're not able to locate the evidence, we may request an affidavit that details how you searched, where you searched, when you searched, who did the search, what you came across. And then, of course, we may come and request a search with you if we feel that maybe it's out there, but no one's been able to locate it. And we'll tell a few stories of some times when we found evidence when others haven't been able to here shortly. So one thing that I'm sure you all are at least vaguely familiar with is NCGS 15A-268. It's the Preservation of Biological Evidence statute. It's a super important statute, and it applies to all custodial agencies, including us. It requires you to preserve physical evidence that's reasonably likely to contain biological evidence for some period of time. And I won't get into all the details, but it depends on the type of crime, whether or not the person is still incarcerated, whether or not they fled, things like that. But what I did want to read to you is subsection A, which talks about what physical and biological evidence is, so that you kind of get a really good idea of what this entails. It says, as used in this section, the term biological evidence includes the contents of a sexual assault examination kit or any item that contains blood, semen, hair, saliva, skin tissue, fingerprints, or other identifiable human biological material that may reasonably be used to incriminate or exculpate any person in the criminal investigation, whether that material is cataloged separately on a slide or swab, in a test tube, or some other similar method, or is present on clothing, ligatures, bedding, or other household materials, drinking cups, cigarettes, or any other item of evidence. So I think it's easier to say in plain English, that means everything. So keep that in mind when you're thinking about biological evidence and what that is. What the statute also does is require you to preserve it in a manner reasonably calculated to prevent contamination or degradation. One of the things that we see so often is storage facilities that are not climate controlled, and we understand that this may be a resource issue, but what I want you to keep in mind is that What is recommended is a low humidity below 60% and a temperature below 75 degrees. So if you have your evidence outside in what we like to call hot boxes, the like storage containers that have no climate control, you may be in risk of being in violation of the statute. So keep that in mind. It also requires you to keep a continuous chain of custody for all of your items, securely retain them, and provide sufficient documentation such that the evidence can be located. If I haven't scared you yet, I want to talk a little bit about where things can go wrong. The first one that I've noted is improper conditions and degradation. Where have we found evidence? We found evidence in attics, basements, storage cubes, all sorts of areas, desks. We've heard that in the olden days, people often stored their evidence in trunks of cars. I think that everyone understands now that that's not the best place for them because, again, those aren't climate controlled. The storage cubes that you have outside that don't have any kind of air conditioning or dehumidifier, if it's 90 degrees outside, which is so often gets in this part of the state and others, those cubes are probably going to be in excess of 120 degrees. So when you think about that, just give that some thought. And again, I know that resources are an issue, but when it comes down to it, that's probably not something you're going to be able to argue if someone's got a good claim. We see it with innocence claims, but it can happen in other ways. That may come back to HERDA department, so be mindful of that.
One thing we talked to law enforcement about when we have done searches and have found issues and kind of addressed the issues with them, she said connexes or storage and warehouses and that kind of thing that don't have proper climate. Every time we get feedback that it's a resource issue, everyone has a resource issue, but the resource issue of, you know, if there is an innocent inmate or a cold case or the wrong person, whatever the situation is, you're opening your department up for huge liability and you individually. We've seen numerous evidence custodians be named in lawsuits, and I know that a lot of the evidence custodians we talk to think that can't happen. I know one right now who is being sued for a case 20 years old individually, so it can happen. You're responsible not just for the evidence that comes in when you're here, but for the evidence that came in when you weren't here.
Another thing that we see, probably in 85% of our cases, are floods. We're often told that a certain evidence storage facility was flooded. This happens particularly down east, but other places as well. Be mindful of that when you're storing evidence. If you're at sea level, you probably don't want evidence on the floor. If you know you have a leaky pipe, you probably don't want evidence underneath it. But in the event that something is destroyed in a flood, the best practice at that point is to document what was destroyed. Time and again, we're told a flood happened, but no one can tell us what was destroyed in the flood. So get in there and figure out what's gone, which cases have evidence destroyed, and document that. And then obviously I've already mentioned high temperatures and high humidity. Another big issue that departments have, and this one tends to be a resource issue as well, are multiple evidence rooms. You know, it's great if you have a room this size and you can have all of your evidence in it, and you've got, as we learned in training, a gun room and a drug room, all of that, place for money separate. But the reality is a lot of you, especially at smaller departments, don't have those resources. And so what you find is evidence in multiple locations. We recently did a search, and I think that we found evidence in 13 different locations. One of the problems was we found evidence in a place that no one knew there was evidence. So be mindful of that. If you have the ability to move everything into a central location or into 2 locations instead of 13, that can be important. It can be really difficult to track your evidence, especially if you don't have some kind of tracking mechanism. And that particular department didn't. They didn't have any inventory of their evidence and literally could not tell us where anything was or what they had. So that was a big issue.
And a lot of times that happens because at sheriff's department and law enforcement clerks, you have a huge high turnover of the people leading the department. But again, if your sheriff thinks that he's not responsible for the evidence that was there prior to him, he's wrong. So in this particular search that she's talking about, they didn't even know that they had evidence. And actually, they're in the process of destroying correctly a lot of it. They didn't even know it was there. And the reason they didn't know it is because a different sheriff had been in power or different detectives. You know, a lot of times when they come in, they wipe out everyone. And that's kind of what happened in that case.
Improper documentation is another one. This goes along with high turnover, lost logs, different styles of documentation, and inventory. I can't stress the importance of knowing what you've got. I think that the statute requires that when it says you have to be able to find evidence. Without some tracking system, you're not going to be able to do that. Be careful with blanket destruction orders. You know, if you want to get a destruction order for multiple cases, it's probably fine, but they really need to outline everything that's being destroyed. Just a blanket order can get you in trouble sometimes, and we had one where everyone said, you know, everything's destroyed, here's a destruction order, but when you really actually looked at the destruction order, it outlined everything that was destroyed, and the rape kit hadn't been destroyed pursuant to the court order. So even though everyone had said, well, everything's destroyed, we have a court order, we were able to talk to the correct agencies and locate a rape kit. It's a single perpetrator rape, and who knows, maybe we will find out whether the person did it or if someone else committed that crime. But if you have a destruction order that lists everything that's being destroyed, it covers your bases as well. Another thing that can happen is destruction in violation of the law. As I said, I'm not getting into the nuances of that law, but there are some very specific things that you have to do to destroy biological evidence in certain cases. And so you want to make sure that you are doing that properly. Again, keeping up with changes in the law. Again, another department had kind of a policy of these blanket destruction orders, and were just destroying everything pursuant to what they thought was the law. And later found out through our process that they had destroyed evidence in violation of the law. It was pursuant to their policy, but they hadn't kept up with the law. And so that was one of the things that we were able to point out to them, and they fixed it, and that's good going forward, but they've opened themselves up to potential civil liability if anyone ever digs deeper into that. Another issue that we see is contamination. Items stored together, but I think bigger than that is items that are opened and then never resealed. This happens most often when evidence goes to court. Clerks' offices tend to perhaps think they may be immune to this statute. It is rare, if ever, that we go to a clerk's office to collect evidence that has been resealed. And so I think that that is important for you all, because eventually, whether clerks know it or not, legal counsel at the administrative office of the courts has actually got a policy that says as soon as the appeals process is over, evidence should be returned to your agencies. It doesn't happen, I know that, because we find stuff at clerk's offices regularly, but in the event that it is returned to you, think of the chain of custody nightmare that you all have if evidence has been improperly stored. It's a lot harder to explain, and certainly you can protect yourself by sealing it in, but there is going to be that gap where it was open. So if you ever have the opportunity to have discussions with clerks or your DAs, that may be something that you want to mention. Lack of resources. So we get this all the time. It is with storage, but another lack of resources that we see, and we hear you all say, is you have many hats. You know, you're not just responsible for evidence. So although you may be responsible for more than one thing, you are responsible for evidence, and you can't let it pile up, back up. We were at an agency recently, and they had their lead detectives were just kind of assigned to the evidence room as well. We conducted a search, and there was a pile of evidence, and we asked, you know, what is this evidence? And they said, that's all of our evidence that is waiting to be entered into the evidence room. Physically sitting in the evidence room, but it hadn't been given a location. And it dated back to 2009. This was in 2013. So, lack of resources, yes, but you're still responsible for it. And that's the new stuff. That's the stuff that's pending. So I think that it's important to keep, keep it real, and if you're having those backlog problems, then go to someone at the chain and explain to them, we're required to keep this stuff and keep it in a certain manner, and here's where we can get caught for that. Obviously, no space for storage, no inventory. I think we've talked about that. I'll give 2 examples of searches we've done. Because there was no inventory or incomplete inventory, for 2 smaller agencies, one search took us 5 days with 5 Innocence Commission personnel and 2 law enforcement personnel to do the search. The other one took 4 days with 2 Innocence Commission personnel and at any given time 2 to 4 law enforcement personnel. That is not only a lot on us, but that's a lot on y'all too. We have to come to your agency and take a week of your time and several of your folks to get through everything. In one of those cases, we didn't find what we were looking for. In another one, we actually found evidence where we had been told it doesn't exist. So, it's important. And then obviously the changing command, we've hit on this. That's just because people rotate in and out of the evidence room or your leaders rotate in and out of your agency, you're responsible for everything that's in that evidence room at any given time, not just the stuff that comes in while you're there. So missing evidence can be located. We've located it at least 9 times, typically with joint searches with law enforcement agencies. And so if we ask you to search, and you've already searched, we're asking you to search again, because we have found it in 9 times. A couple of those cases, a defendant's request for DNA testing had been denied, because people from law enforcement agencies to defense attorneys had gone before judges and said, the evidence isn't here, and so the judge denied it because the evidence is gone. We later were able to locate that evidence. Another example of that is we got destruction orders from a law enforcement agency. The destruction orders were marked destroyed, but when you actually looked at their evidence forms, you could see that stuff was returned from the SBI, now State Crime Lab, in a year later than the destruction occurred. And so we were able to say, do you by chance have this? And they did. They just misfiled the paperwork, and the evidence was still there.
That was one of the reasons that I asked you about returning that. We're seeing that a lot, and that maybe you had the law enforcement agency had a case from 1981. They destroyed everything, or at least stated they do. We don't know because the documentation wasn't required then. But then in 2007, maybe they got all this evidence returned, and they have kept it pursuant to the law. So, their initial reaction when I call or when we call you up and say, do you have evidence from a 1981 rape case, you're going to say, I don't have any evidence past 1995. I mean, we hear those standard answers all the time because you know what you have in your room. But sometimes what you have is something returned from the SBI any time over that 30-year period. We've seen that multiple times we've found evidence that way.
Like in 2007, up through 2007, there was a unsolved latent file.
We know it well.
And so then some very, very, very old cases we determined that this stuff should be considered evidence. And so it was all packaged up and sent out. And so there should be, any of those cases that were in our unsolved latent file did go back at that time. When you said 2007, I'm like, ooh, I know that year well, because we've done the same.
Well, and other times, but
clear.
certainly 2007 is the year, that's why I mentioned that, because we're seeing that a lot.
And the only other thing that, again, the crime lab is not a retention, has never been retention, but back in the day, pre-Susie day, certain stuff that was continuing to be solved, APHIS wasn't, you couldn't upload and leave it there. CODIS wasn't around, and so as these databases have become available, the need to retain evidence has ended. But we had bloodstains. Sarah spent, how long did you?
2 years.
2 years going through stuff where we had made a liquid, we had taken a liquid bloodstain, made a bloodstain. We weren't considering it evidence at the time. It's now been determined it is now considered evidence, and we have started packaging up and mailing that back. And so there are bloodstains from early 90s to late 90s that we have back.
We've seen that too with extracts. We've of course found a lot of extracts at the SBI that no one no one being the law enforcement agencies were aware of. And then latent prints, I know that the policy was, I think they went through and tried to return everything within a 5-year period, but we found 2 cases where the prints were actually in the latent file. So things happen, right? Other personnel is there. I mean, that's why we're asking you to look, not because we think anyone's up to anything, but just to be sure that there's nothing there. Another case not involving the SBI, they found latent prints in the police file.
We've had at least 2 of those. So yes, that's why we're asking. We also ask that you look in all of the storage locations. If you hear us come to you and say, is there anywhere else evidence may have been stored 20 years ago, we're asking you to find someone in the department or let us talk to someone in the department who may know. And that has happened too. We recently interviewed a detective who said, yeah, evidence back then was found in such and such place. And while we didn't find the evidence there, we did locate their law enforcement file, which had been missing for several years. So that's, that's another thing that we're asking for. All locations, anywhere it could have been. Also, under various labels. Sometimes things are labeled by year, victim, codependent, officer. Even if your policy now is to store everything by suspect name or by victim name, we're asking you to look under these other labels that maybe it could have been. We see this a lot if cases go cold for a while, and so maybe it was a 1980 case, but it's actually not tried until 1992. Sometimes you're looking under 1980 and it's filed under 1992 or vice versa.
And law enforcement, you guys keep your files in different ways. Sometimes you file under victim, defendant name, OCA number, whatever. So we are a lot of times requesting all of the information. We found a lot of cases under victim names that they were not able to find when they searched for defendant names.
Also, if you've got any boxes that are unlabeled or if there's any reason to suspect something is mislabeled, that's a good place to find old stuff.
And an example of that is we recently had that. We had a lot of boxes and envelopes that were not labeled, and the agency had to open them. They didn't contain our evidence, but they did contain drugs and money. The department had to deal with quite a lot of drugs and money that they weren't aware of. So if you have unlabeled items, figure out why they're unlabeled. And as an evidence custodian, you can open them and sign them and put what's in them. We actually, in our searches, if anything is unlabeled, we'll have you open it. And the really good investigators who are with us will relabel everything while we're there. That doesn't always happen, but
I recommend it. The bottom line really is search everywhere, and don't, if we're asking you to search somewhere you think you've already searched, just understand that there's a reason that we're doing it, because we have found it in several cases. And a lot of times, finding that evidence has ultimately ended up with some DNA testing that proved guilt. And we think that that's a great thing too. The other thing that we want you to understand is, if there is an innocent person, then the real perpetrator is out there, and your victim is still being victimized because the real perpetrator has not been brought to justice. So that's something that we always keep in mind as well.
do you guys have any questions?
Take it back to slide about what we received the contract and all that.
What was the question?
He wanted to see this slide that says what to do when you hear from us. Sure. I'll talk a little bit about that. If you get the preserved letter, it generally means we've just opened an investigation. We believe there could be evidence out there, and we just don't want anything to happen to it while we are working our cases. We do have a backlog at our agency, so we don't want something to get destroyed legally while we are trying to get to that case. If you get a production letter or a phone call from us and we're asking for something more, then that means that we've actually moved into an investigative stage with the case and are trying to actively work on the case at that time.
These preserved letters, are they addressed to the chief or the sheriff or?
So what we've started doing, because
After
our last meeting, there were some concerns expressed that they weren't trickling down to the evidence custodian. So what we're doing now is they go to the district attorney, they go to the sheriff or the chief of police, they'll go to the clerk if there was a trial or we believe evidence was introduced, and then we're also copying evidence custodian. If we know your name, because we've worked with you before, we'll address it to you specifically. If we don't, we're just sending a second letter that says attention evidence custodian. So we made that change in response to some concerns we heard during our March meeting here at the beach, because some of those weren't trickling down to the people who actually are working in the evidence rooms.
And I sent ours to the records section, so you got the full record. Like we had to go to a library and get it off microfiche, but we got everything. For you to stand for this last game.
Okay.
I do a lot of teaching in my field, and I've had students inquire about your organization. From what pool do you hire, and who all serves on the commission? I saw the slide where it has, sheriffs and judges and whatnot serving on a committee, but who actually does the analysis of the evidence?
So the commissioners are appointed, so they're never hired. They have, outside jobs. But as far as the staff, we have 9, actually 8 staff members right now. 9 is the most we've ever had. We definitely take interns as far as law students and things like that during the summer. But the commission staff is the one that reviews and investigates all innocence claims. So the determination about whether to move a case forward or to close a case, call a case for hearing, that kind of stuff, is only made by our executive director or myself. And what the general kind of process of that is, you get a lot of claims, they fill out questionnaires, you start gathering their information and put it together in a case memo and start reviewing it to determine, one, are they claiming innocence, and if they are, what would prove it or what could we do?
I think to answer your question a little bit more about actual hiring, all of our positions when we post are posted on the state personnel website. We are an independent commission, but we are a state agency, and we fall under the administrative office of the courts. So typically, we have attorneys on staff, but we also have non-attorney investigators. Even though Sharon and I are associate director and associate counsel, we still investigate claims. I say that probably 85% of the work I do is non-legal work, it's investigative in nature. So we don't have any sworn personnel currently. That's not currently in our statute to do that, but we do have investigators who do not have law licenses.
Does that answer your question?
Somewhat. Like when you re-examine the evidence, who actually examines it? Do you send it to a private lab?
Oh, sure. We send it normally to a private lab, sometimes to the SBI, the crime lab. It just depends on what the evidence is. If it's been tested and their policies are a little bit different, like maybe if they can't retest something, we'll go to a private lab. If there's testing that the crime lab doesn't conduct, mitochondrial DNA, stuff like that, we'll send it to a private crime lab or a private lab for testing. We normally use them all over the country, but there's one primarily that we use.
One of the reasons that you said you would not take the case was that if they pled to it.
No, ma'am, we do take pleas.
Okay.
What I said, and I think I got tongue-tied on it, but if it gets that far, so if it gets to formal inquiry, if we find verifiable, credible evidence to present to show that there is an innocence case, all 8 of the commissioners must vote unanimously to send it forward. And that's written by our statute. That translates to a plea case is harder than a trial. The reason being that someone pled to a crime, so they just would like more people voting. Go ahead.
Yeah, got a little more up there about the commission will send a release when a case is closed. Have you ever had situations where you reopen on a claim?
Yes, we have.
Okay, so, just because we get a release doesn't mean that we can now go and seek out a destruction order or execute the destruction order.
Well, you can. What it means is we're not under our statute anymore. So you can destroy or keep evidence but you can't, right. We're not requiring you to keep it anymore.
Okay.
But you might be required under the evidence preservation to keep it. The reason I think we've reopened a couple because testing, a couple of methods changed. So, and that's always probably going to happen. The truth is, DNA is advancing every day. Can I say that we won't come back? We may, unless it proves guilt. If DNA testing hasn't proven anything, we may reopen the case.
The key to that, though, is if you got your destruction order under the law and have followed all the proper channels, and we come back to you and we reopen the case and are now asking you to preserve, what we want from you then is just a letter or a phone call and some documentation that you destroyed it. Here's the destruction order, here's, you know, the date and time stamp that it was destroyed, who it was witnessed by. And we'll know that. I mean, certainly it's that person's loss, but you're following the law, and that's all we can ask you to do.
Any other questions? Okay. Thank you.